बिस्मिल्लाहिर्रहमानिर्रहीम लीगल फोरम में आप सबको खुशामदीद। टुडे वी आर गोइंग टू डिस्कस about the joinder of the charges. This is the topic related to the CrPC. In the part 1 of this video, we have discussed about the charge and thoroughly, and we have not discussed the sections particularly. So section 221 of the CrPC deals with the charge. It says about the definition of the charge. It says if there is a name of any charge mentioned in the CrPC, if any offense constituting any charge, if its name is mentioned, so we will give the name of that charge to that charge. Okay, after that the language of the charge should be the language of the court. This was about the section 221, and section 222 says about the particulars of the charge, that on which occasion the offense was committed, where it was committed, by whom it was committed, on which date it was committed. After that comes the section 223. It deals with the if there is a loophole, if there is a gap left by section 221 or section 222, that is filled by the section 223. That it says you have to describe this offense. You have to tell the accused that this is the offense you have committed and this is the charge against you. The charge has been framed against you. This is the charge. So he must get notice, he must get knowledge, idea that what is the charge against him and on what grounds he should defend himself. Okay, so this is the main objective of framing of charge, or giving him the notice that this is the charge against you and you have to defend yourself on this against this charge. Okay, now comes the alteration of the charge, that is section 227. Section 227 says that before the judgment you can alter the charge, but it should not be prejudicious to the accused. Okay, it should be a fair, it should be a legal. Okay, it should not be a prejudice, it should not be a biased one. It should be the legal one, it should be the appropriate one. And what is the effect that is said in the section 231, that the effect of alteration of the charge is that you will recall, you will resummon, you will re-examine, you will re-cross-examine the witnesses. After that comes the joinder of the charges, the main topic of our video. So in the previous video we thoroughly gave you concept of what is joinder charges, what is the general rule, what are the exceptions to that. Today we are going to discuss these things in detail. So the topic is joinder of charges. It starts from the section 233. It says the general rule: separate charges for different offenses. For each offense, if there are 5 offenses are committed, so there should be 5 different charges for that. This is the general rule. If there are 2 offenses committed by any person, there should be 2 different charges for him on him. Okay, but this is a general rule, but there are some exceptions mentioned in section 234, 235 and 236 and 239. Before going to these sections, I must tell you that when, on which occasions you will frame one charge over different offenses. Okay, first of all you have to look at the time of proximity, the gap between the one offense and the other offense. What is the gap? Okay, what is the gap between the first offense and the other offense? That is called time of proximity. If there is a less gap, then the one trial for different offenses can be obtained. Then the community of purpose and community of action. Commute karna hai. You have to commute the purpose and action of that person. That what was the purpose of that person and what was the action, what was, okay, for suppose his purpose was to kill someone. So first what he did, first he detained a person, then he beated him, and then he injured him, and after that he killed him. So this is a series of actions. What was his purpose? His purpose was killing. Okay, what was his action? His actions was different, like detainment, beating, injuring, and then killing in the end. So this is the time of proximity. So he has done all these things in one transaction. First what he did, he detained, then he beated him, and then he injured him, and finally he killed him. When the series of offenses like detention, beating, injure and kill are connected, are in one transaction, these are different offenses. but committed by one person in same transaction or committed by different person in the same transaction in the same time, in the time approximate in the less time, so that will be connected, that will be the one transaction. So for that there will be one charge, there will be one charge will be framed for that. Okay, one transaction, one charge, one transaction, one charge. For suppose first he detains and he leaves and he exonerates him, and after that he again detains, okay, or he beats him, but he doesn't detain. So this is not the same transaction. The what is the same transaction? First he detains, then he beats and injures and kills. So this is what, this is the different offenses committed in the same transaction, or these offenses are connected in the same sequence, in the same series. So for these sequence, for these connection, there will be a one charge. What is the general rule? General rule is that for each offense, for detention, for beating, for injuring, for killing, there are different punishments, there will be different charges. But here, if these offenses are committed in the same series, in the same transaction, in the one transaction, that will be the one, then the one charge will be the framed. Okay, now this is the general, the introduction or general principle that you have to, how will you will determine that we should frame a one charge. So you have to look at these three things: time of proximity, community of action, and community of purpose and community of action. So if these things are there, then one charge will be framed. Now you will notice in section 234, 235, 236, all these three things. Okay, what is section 234 is saying? That it is saying that three offenses are committed within the period of 1 year, within the period of 12 months. If three offenses are committed, then there will be a one trial, there will be a one trial, there will be a one trial. So this is a section 234 is saying that if three offenses within the 12 months, within the space of 12 months, first offense was committed in the start of 222 on 3rd January, the second was committed in the middle, for suppose in the June, in the May, and the third was committed in the December 3, December 4, like that. So this is called three different offenses in within the 1 year. So there will be a one trial for that, there will be a one trial for that. So first we have to see that a person has committed an offense, okay, and he has committed the other offense within the two more offenses within the space of 1 year, okay, within the 1 year. So it will be treated as one trial, there will be a one charge on him. Section 235 says trial for more than one offense. If there are more than one offenses, then what will be the trial? The trial will be the one. There will be a one trial for more than one offenses. For suppose if the offenses are connected with each other, if the offenses are connected with each other, so that is called committee of purpose or committee of action. Okay? So there is a connection, there is a one transaction. For suppose a person is entering in a house, he is trespassing in a house. The section 454 of the PPC deals with that, discusses about the punishment of the house breaking, and he goes there with the intention, he has an intention that he will go there and he will commit an adult crime, offense of adultery, and he goes there and he commits the adultery. So then this person will be treated, the charge will be framed only one, and it will be treated in the one trial. The trial will be only one. There will be no separate charge, separate trial for the 454 or 497. There will be a one trial, because these both actions are connected with each other. These are done in the same transaction. If it would have been happened like this, if on the one day he comes and he only trespasses, house breaks, okay, he trespasses only, and he steals something, then he will be treated with the same transaction with the one trial, with the house breaking and with the theft, So this is the trials for more than one offense. So house breaking is an offense, trespassing is an offense, and adultery is also an offense. After that, there is a two definition. If the offenses are of two definitions, if one offense has two definitions, then for suppose there is a stolen property, some person has received a stolen property and other person is hiding it or hiding the stolen property, so they both are committing the same offense, okay, they both are committing the same offense, so they will be also charged with the same, with the one trial. For suppose a person has received a stolen property and he knows this is a stolen property, and the other person helps him to hide that stolen property. So the both will be tried in the under one trial. If the acts constituting one offense, there are different offenses has been committed, but they are constituting one offense, so that there will be also one charge. For suppose if there is a person who going to rob someone, okay, so while robbing someone, he is committing a crime of robbery, and he intentionally hurting that person, okay, to whom he is robbing. Then the three offenses he is committed. First, 392, okay, the robbery. 394, hurting someone while robbery, and 323, the diyat for that hurt. So there will be not different charges for the each section, okay. There will be only one charge and one trial, because the action of that robber is this in the same transaction, in the one transaction, and there is a proximity of time is also very less, okay. There is very less gap between these actions. So there is a community of purpose, community of action. So he had an intention to hurt that one. He said, if the person I am going to rob, if he puts any kind of hindrance, then I will hurt him. So there was a hindrance. So there was a community of action, community of purpose, and time of proximity. So this person will be also charged under one trial. Only one charge will be framed for this person. This was all about the section 235. The section 235 subclass 1 says trial for more than one offense, and the section subclass 2 says if there are two definitions for the one offense, and if there are different offenses and they are constituting one offense. So this is dealt with the section 235. So there will be also one trial, one charge framed for them, because these all actions, these all crimes, these all offenses are done in the same transaction, in the one in the series of actions, series of offenses. Now comes to the 236. 236 is a doubtful. Any offense you doubtful, okay, breach of trust, trespass, okay. Now in this you can put the and, okay. First you will say trespass, breach of trust, criminal breach of trust. So all you put and or, okay. So that person will be also treated under the one trial, and only the one charge will be framed for that. When you are not sure, when you are doubtful that it's not he would have committed trespass, theft, criminal breach of the trust, okay, adultery. So while writing that he has committed these offenses, you will put and or in these. So if you are putting and or in these things, the court will not consider these different offenses. These are different offenses, but the transaction of these offenses will be the one, and the person will be treated under the one trial. There will be only one charge. Now comes the section 239 of these exceptions. The first is 234, when there are there are three offenses within the 12 months. But section 235 deals with the more than one offenses. Two definition for the one offense, or different offenses constituting one offense. And 236, when the offense is doubtful, when there is a doubt, there's a doubt, okay, then there will be also one trial. There are 239. This was all about the offenses. These three sections were all about the offenses. But now 239 is about the persons who will be charged, or who will be charged jointly. The mentioned in this section is that the person who are all the doers of any action or any offense will be charged with the one trial or with the one charge. For suppose there are four persons, okay, they are going to rob, or they are going to theft anybody, going for theft to any house. So all four persons will be charged with the theft. So all those four persons will be charged with the robbery. So there will be one charge for them, there will be one trial for them. It will not be that for A there should be a different trial, different charge, for B there should be a different charge, and for C there should be a different charge. No, they all will be treated with the same charge. Okay, it was same offense in the same transaction, so they will be also treated under the one trial. In the section, in the subclass D or E, it is said that if there is a different kind of offenses but they are done in the same transaction, they will be also treated in the one trial. There will be also one charge, and those all persons who are indulged in that will also be treated jointly and will also be charged jointly. After that, there is a doer and abettor. The doer and abettor, they will be also charged jointly. The common intention, for suppose like in the protest, someone destroys the government property, so they all will be charged with the jointly. All doers, all helpers, like a person who is helping someone in the counterfeit coin. Okay, counterfeit coins, one is maker. Okay, the other one is promoting or someone selling or doing business or committing fraud with someone. So they all persons, like one the maker, the person who is committing fraud on the basis of the counterfeit coin. Okay, they all will charge jointly under section 239. So section 239 tells us all about the persons who will be charged jointly. Now in the last comes the section 240. 240 is saying that if there are three different charges on a person, and a person is convicted in one charge and two charges are not proved, so the two charges will be withdrawn. Okay, now person who is convicted for the two or more charges or for any charges, so if one charge is proved and he is convicted for the one charge, other charges are not proved, so the other charges will be withdrawn. So now comes the objectives. What is the objectives of these objections? What are the objectives of these objections? First of all, to avoid the repetition of witnesses. Okay, first you will call one person for one trial. Okay, whether he has committed the adultery or not, so you will call the witnesses. Whether he has committed the theft or trespass or not, you will call other witnesses. Okay, so for the trespassing, you will call the witnesses again, and for the theft, or adultery, you will call the witnesses again. So the witnesses are coming for the theft separately, and they are coming for the adultery separately. So there will be to avoid this repetition of the witnesses. That's why there are the exceptions. So there should be no avoid. We should avoid the repetition of these witnesses, that they should come, they should give the witnesses, and they should give their statement first for the trespassing, and after that they should come and they should give the witness their statements for the adultery. So avoid these repetition, and to save the time of the honorable court, there are some exceptions. Okay, like if there are 4 persons charged with the robbery, so for each person, there should be not first A should be tried. Okay, first there should be a trial for the A. So the witnesses will come and will give their testimony or will give their statements against A. Now again they will come for the B, C and D. So they are coming again and again, and it is taking more time for the court to decide. So they will come once and they will give the statement once, and they will give the testimony once. So to avoid the repetition of the witnesses, to save the time of the court, and to avoid the multiplicity of the trials, there are these exceptions. So these exceptions have some objectives. That's why they are put in the CrPC, and that's why they have some kind of scope for the CrPC. So this was all about the joinder of the charges. So first of all, in the first part of the video, that is published, in which we have discussed about the charge. Okay, in this video we have discussed about the joinder of charges. In the start, I have mentioned the sections of the charge, like 221 to 240 we have discussed till here. So this is all about the joinder of charges. This is all. Thank you. Allah.